Imagine firing an employee, right? You point to this rock-solid, like 15-page contract to justify their minimal severance.
Yeah, you think you're totally covered.
Exactly. Only for a judge to just throw the entire thing in the trash over a single sentence in your vacation policy. So welcome to today's deep dive. Our mission today is to dismantle a pretty financially devastating myth in the 2026 Ontario employment landscape.
Right. And specifically, we're tackling this dangerous assumption that, paying your sales staff heavily or even entirely on commission just magically exempts your business from the Employment Standards Act or the ESA.
Which is wild. And to guide us, we are unpacking a really comprehensive legal masterclass from Tony Wong at HCW Law. So where do companies get this wrong right out of the gate? Do they just lump all salespeople together into one big bucket?
They do, yeah. And to understand the danger, you really have to break the habit of treating commission earners as a single monolith. The law categorizes them strictly. So pure professionals, like real estate agents, we have statutory exemptions.
Yes.
But take a hybrid auto salesperson. Even if they are 100% commissioned, if they work 40 hours and sell 0 cars, the dealership still legally owes them a minimum wage top-up.
Right. But what about the tech world or B2B, like the inside account executives and sales development reps?
That is the deadliest trap. Employers often misclassify standard inside sales reps as exempt traveling salespeople just to dodge those ESA rules. What's fascinating here is how the remote work boom completely destroyed that classical exemption.
How so?
Well, the original 1970s law assumed a traveling rep was, highly autonomous, out on the road, and basically impossible to monitor.
Right. But today, an enterprise rep is grinding on Salesforce at their kitchen table in sweatpants.
Exactly. Legally speaking, they are an inside sales rep. Their home office is really just an integrated extension of the corporate workplace, so they get full ESA protections.
Okay, let's unpack this. So a modern CRM software is basically a digital tracking collar. I mean, if the company dictates your zip code and mandates your daily stand-ups, you aren't an independent road warrior. You're under their total control.
Spot on. And because these remote workers are fully covered employees, standard corporate payroll practices suddenly become, illegal wage theft.
Wait, really? Give me a real-world example of that.
Take a recoverable commission draw, right? Like an advance against future earnings.
Yeah, super common.
Very common. But no matter what, that draw can never push a biweekly paycheck below the $1,408 minimum wage floor, period. Furthermore, vacation pay must be calculated on gross wages.
Meaning?
Meaning it statutorily includes every single dollar of commission they earn.
Here's where it gets really interesting. What happens if a company just ignores that? Let's say their handbook has a standard use-it-or-lose-it vacation policy.
This brings us to the Waxdale domino effect. Courts view employment contracts and corporate policies as a single, indivisible ecosystem.
Oh, wow. So the employment agreement is essentially a Jenga tower.
Pretty much.
If one block, say, a non-compliant vacation policy that forces you to forfeit statutory minimums, if that gets pulled out by the courts, the whole thing just collapses.
Precisely. The court will void the entire termination contract from the very start.
That sounds absolutely terrifying for an employer. If the termination clause is voided, what does that actually mean for severance? Does a judge just, decide what's fair?
Yeah, that's called a common law notice, and it can reach up to 24 months of total compensation for senior reps.
24 months? But hold on, surely an employer has the right to manage their own staff. What if the contract explicitly says you only get paid on deals that close while you were actively sitting at your desk?
Well, because the contract is voided by that domino effect we talked about, those active employment clauses just vanish with it.
No way.
Oh, yeah. Fired reps are legally entitled to pipeline commissions that close months after they're terminated. If we connect this to the bigger picture, it's a massive warning against firing a rep right before a massive deal closes just to avoid paying them out.
Oh, wow. So a company thinks they're saving a commission payout, but they're actually buying a massive lawsuit.
Exactly. And it invites massive punitive damages in court, plus Ministry of Labor fines reaching up to $750,000 for repeat offenders.
That is insane. What if a company just tries to, tighten the belt instead of firing someone? Hey, times are tough. We're cutting your commission rate by maybe 15 or 20%.
You can't do that unilaterally.
Yeah.
Changing the fundamental terms of how someone is paid without their consent triggers what the law calls constructive dismissal.
Ah, right.
Yeah, the courts view that fundamental alteration as essentially firing the employee, which, again, triggers all those massive severance payouts we just talked about.
So what does this all mean for you listening? It means there's an immediate need for a forensic audit of legacy contracts. I mean, ignorance of these technicalities is just a ticking time bomb, whether you're the employer needing a legal recalibration or the employee trying to protect your rights.
Absolutely. The era of treating these legal technicalities as a simple cost of doing business is definitively over.
We started by talking about that old expectation of absolute certainty in business contracts. But the modern digital workplace has fundamentally changed what employer control actually looks like, which leaves you with something pretty wild to consider.
Oh,
Yeah, if dictating a worker's schedule via a CRM legally turns them into a highly controlled employee, what happens when companies start using AI to actively script and monitor every single word an employee says on a sales call? In the digital age, does the concept of a truly independent salesperson even exist anymore?